Now that we've discussed what is DACA and what it is not, let me discuss who can benefit from DACA. First things first, DACA will be granted to individuals who have come into the United States before their 16th birthday. 2, they have to have continuously lived in the U.S. since June 15, 2007 and up until the present time. This means that even if you entered into the U.S. and were actually in the U.S. On June 15, 2007, you cannot have since left the U.S. 3, you actually have to have been present when this directive was passed by Obama's administration, and that is June 15, 2012. And you also have to be present in the U.S. when you actually submit this request to USCIS. 4, you cannot have lawful presence in the U.S. at this time or on June 15, 2012. This means you must have entered into the U.S. without papers before June 15, 2012, or if you entered lawfully, your immigration must have expired by June 15, 2012. In other words, if you anticipate that your status is going to expire in the near future, you can't apply for DACA. It's not available to you. It's only available to individuals that were out of status at the time that the directive was passed on June 15, 2012. Next, you have to be at least 15 years old at the time of filing. If you have never been in deportation proceedings or your proceedings were terminated, however, if you are currently in deportation proceedings or have a voluntary departure order or have a deportation order and you are not in detention, you may request deferred action. Let me say that a different way. If you are not in proceedings at this time, you have to at least be 15 years old to apply for this. However, if you are a juvenile detainee, in other words, if you are under 15 years old and you are in deportation, either in deportation or detained by DHS, you are then eligible for DACA. However, if you're not detained, if you're not in removal proceedings, and you are under 15, you cannot apply for DACA. Next, you cannot have reached your 31st birthday as of June 15, 2012. So if you had not turned yet 31 on the date that this directive was ordered, but you are 31 years old now, you can still apply for DACA. In other words, let's just say that your birthday was on July 17, 2012, and that is when you turned 31. But on the date that the directive was passed on June 15, 2012, you had yet to turn 31, you are still eligible to apply for DACA. The next requirement for DACA is that you are currently in school, have graduated or obtained a certificate of completion of high school or a GED, and or if you've been honorably discharged from the Coast Guard or the U.S. Armed Forces. If you're not in school yet, and, well, let me rephrase that. If you have not obtained a GED or graduated from high school, but you are also otherwise eligible for DACA, the advice is to get yourself enrolled in a GED program immediately. Now, there are other education options available if you are not a high school graduate, and that includes if you are still in primary or secondary school. Remember, the starting age to file for DACA is 15. So if you're 15 years old, you're presumably in high school and you have not graduated from high school yet. So as long as you can prove that you're actually enrolled in high school right now, that's good enough. Also, if you can show that you're enrolled in an education or literacy or career training program, or an education program assisting students either in obtaining a regular high school diploma or a recognized equivalent under the law. Now, if you have questions about whether or not the program that you are enrolled in would qualify, it's advised that you either visit the USCIS.gov website, which has a wonderful itemized FAQ, which is frequently asked questions in relation to DACA, or have a consult with a trusted attorney or an immigration legal service provider in your local area. However, The basics would be either be enrolled in school, have a high school diploma, or a GED certificate at the least. The next requirement is you cannot have been convicted of any felony offense. A felony is a federal or a state or a local crime that's punishable by imprisonment for a term exceeding 1 year. That's a felony. Now, a lot of people think, okay, well, if I've got a misdemeanor under my belt, I'm in the clear. Not so fast. Another requirement is that you cannot have been convicted of a significant misdemeanor or offense. A misdemeanor is a crime for which the maximum term of imprisonment is 1 year or less, but more than 5 days. And DHS considers the following to be significant misdemeanors: an offense of domestic violence, sexual abuse or exploitation, burglary, unlawful possession of a firearm, drug distribution or trafficking, driving under the influence. And these offenses are considered significant misdemeanors regardless of the length of sentencing that is imposed. Now, it's important to understand and adhere to these guidelines, because depending on the jurisdiction that you live in, what may be considered a misdemeanor, for instance, in D.C., may not be considered a misdemeanor in New Jersey or in Montana. So it's important that you understand what DHS is outlining to be a significant misdemeanor. Now, that's one type of misdemeanor that would render you ineligible. Another is you cannot have been convicted of 3 or more misdemeanor offenses. The types of offenses that count towards the 3 or more misdemeanor offenses include any misdemeanor not listed under the significant misdemeanor for which you have been sentenced to fewer than 90 days in custody. And this means that even if it's not considered a significant misdemeanor, if it's considered a misdemeanor and you've got more than 3, well, 3 or more, that could render you ineligible for DACA. Now, DHS has let us know that they will not count minor traffic offenses as misdemeanors. DHS will also not count immigration-related offenses created by state immigration laws. For instance, Arizona and Alabama have on their books some rather strict immigration laws that would make it a crime, for instance, to drive a car and have undocumented individuals in the car. They have labeled those to be considered as trafficking of undocumented individuals. So DHS is basically saying, if you happen to be somebody that's caught in the web of those types of laws, being charged with those laws will not be counted against you as misdemeanors for the sake of a DACA request. And also, DHS will look at all the circumstances in a case-by-case basis to decide whether a person who has committed a criminal offense will be given deferred action. What this means is, even if whatever crime that you have been charged with does not fall in any of these categories that would render you ineligible for DACA, the last word is DHS. If they find that the details of the crime would render you somebody that's not a likable or a viable candidate for DACA, because this is discretionary, they could very well deny you. So what does this mean? Well, let me backtrack a little bit. Another requirement for DACA is that you not pose a threat to national security or public safety. On its face, this sounds like you have to be a terrorist or have been found to be involved in terrorist activities. But DHS has specified this to also include individuals that were involved either presently or in their past in gang-related activities. So unfortunately, this means that if you had been involved in gang-related activities and you are now otherwise a reformed individual and you have left that lifestyle, just the fact that you were at some point in time involved in a gang would render you ineligible for a DACA request. And then, of course, you have to pass a background check. Background checks are part of the application process, as we'll discuss later on, and those are conducted by a biometric appointment at a local application support center. Biometrics is just a fancy word for fingerprints. So in other words, even if you choose to not fill out the form truthfully, the truth will come out when you get your fingerprints taken. And one word of advice is, even if your records have been expunged, or if you're dealing with a crime that is old, say for instance you're now 29, you're otherwise eligible, you've got a high school degree, or maybe you've even got a college degree, you entered into the U.S. before you were 15, and before June 15, 2007, you can prove that you were in the U.S. on June 15, 2012, and you've lived a relatively crime-free life, except for something that you did when you were 17, when you were working at Popeyes and you stole $300 from the cash register. And so now you've got a misdemeanor on your record, and depending on the facts of the jurisdiction that you live in, the misdemeanor could very well fall into the significant misdemeanor category and or the felony offense category. But again, you've lived a relatively crime-free life except for that one infraction, and on top of that, you've actually had your record expunged. When it's time to actually fill out the application, word to the wise, the question is very clear in asking whether or not you've ever been arrested or charged, and the answer is yes, even if the record has been expunged, and even if it happened when you were a minor. And don't be tempted to lie, because that information will come up on your biometrics. So it's important to understand that DACA is discretionary, so that if you're otherwise not eligible, and we'll discuss this further on, this may very well not be the option for you. Now, user alert. Some applicants are clearly eligible for DACA. For many of these people, the process of requesting deferred action will prove to be relatively hassle-free. However, if you have any issues with criminal matters, big or small, if you've kept poor to no personal records, and a lot of the requirements that we just discussed will require having kept, if not meticulous records, at least having access to records. If you've committed any type of immigration fraud in your past, or if you are just confused, you have no idea if the facts in your life add up to the facts that the DACA request form requires from you, it is absolutely crucial that you sit with a reputable immigration attorney or nonprofit organization, or a reputable immigration legal service provider to determine if you should even apply. This is important because if you're not eligible to apply, you could very well find yourself at the top of the food chain for removal proceedings.